The morning of March 15th started like any other Tuesday in Providence Municipal Court. Judge Frank Caprio, now in his mid-70s but still sharper than judges half his age, arrived early as he always did. He had no idea that this particular day would become the most watched courtroom confrontation in internet history. He had no idea that by noon, his name would be trending across every social media platform on the planet. He had no idea that a European news organization had orchestrated something designed to humiliate him on live international television. The setup was calculated. Viktor Novak, one of Europe's most recognizable broadcast journalists, had arrived in Providence with a full camera crew, producers, and what he believed was an airtight legal case designed to expose what he called American judicial incompetence. Novak had built his career on aggressive questioning, confrontational interviews, and his trademark ability to make powerful people look foolish on camera. He was famous in European circles, respected in London's media establishment, feared by politicians from Brussels to Berlin. He had never, in his entire career, encountered a situation he couldn't control through sheer force of personality and media manipulation. Novak's case seemed straightforward on paper. He was representing a major European pharmaceutical corporation in a dispute with an American distributor based in Rhode Island. The contract was complex, the stakes were high, and Novak had convinced himself that this small-town American judge would be completely overwhelmed by the sophistication of international commerce law. What Novak didn't understand was that Judge Caprio had handled international cases, had studied comparative law, and most importantly, had prepared meticulously for this hearing. When Novak walked into the courtroom at exactly 10 a.m., he wore that signature expression that had become his trademark. The look of someone who already knew exactly how this day would end. He carried himself with the confidence of a man who had never truly been challenged. His tailored Italian suit probably cost more than some people's monthly salary. His perfectly styled hair and designer glasses screamed European sophistication and American contempt. The courtroom was packed. Word had gotten out that a famous European broadcaster was coming to Providence Municipal Court. Local news crews had set up cameras in the back. Legal students from nearby law schools sat in the gallery, curious to see how this would unfold. Judge Caprio sat at his bench, reading through the case file one final time, his expression revealing absolutely nothing. "Your Honor," Novak began, not even bothering with basic courtroom courtesy. "Before we begin, I should warn you that this case involves sophisticated international trade law and multinational contract interpretation. It may be beyond the scope of typical municipal court experience." Judge Caprio looked up from his papers, his reading glasses perched on his nose. His expression didn't change. "Mr. Novak," Judge Caprio said calmly, "I appreciate the warning. Now, let's proceed with the case." Novak launched into his argument with the confidence of someone who had rehearsed this moment 100 times. He cited European trade directives, referenced complex international agreements, and threw around terms like force majeure and material breach with the apparent belief that mere vocabulary would overwhelm the elderly American judge sitting before him. He spoke quickly, switching between English and French and German, clearly trying to create the impression that this case was simply too sophisticated for the local court system. "The American distributor," he said, "has fundamentally failed to meet the contractual obligations outlined in our agreement. Our European clients have suffered damages exceeding 12 million euros. The case is straightforward from a legal perspective, even if the context may seem complex to those unfamiliar with international commerce." The courtroom was silent. Everyone waited for Judge Caprio to look confused, to ask for clarification, to demonstrate the limitations that Novak had predicted. Instead, Judge Caprio removed his reading glasses slowly. He set them down on his desk with deliberate precision. Then he did something that made Novak's confidence visibly crack. "Mr. Novak," Judge Caprio said, "I want to make sure I'm understanding your position correctly. Are you arguing that the force majeure clause in Article 7 of your contract supersedes the performance guarantees outlined in Appendix B?" The silence that followed was different from the previous silence. This was the silence of someone realizing they had made a catastrophic miscalculation. Novak's face flickered. Just for a moment, his perfectly maintained media persona glitched. "That's one interpretation," he said, slightly less confident than before. Judge Caprio leaned forward. "It's not an interpretation I'm proposing. It's the only logical reading of the contract language. However, I'm concerned about something else." The judge pulled out a thick document. "During my preparation for this hearing, I reviewed the European Union Trade Directive 2019-847, specifically Article 12, subsection C. That directive, which your client claims governs this contract, explicitly states that force majeure exclusions cannot apply retroactively to damages that occurred before the force majeure event was invoked." Novak opened his mouth to respond, but Judge Caprio continued, his voice carrying the authority of someone who had spent decades preparing for exactly this moment. "Now, according to your own documentation, your client invoked the force majeure clause on January 15th of this year. However, the documentation shows they waited until February 8th to formally notify the American distributor. That's a 24-day gap, during which time they continued to accept partial shipments from the American company without protest. How do you explain that delay?" The courtroom erupted in whispers. Cameras zoomed in on Novak's face as he tried to maintain his composure. One of his producers in the gallery was frantically flipping through documents. The famous broadcaster who had come to humiliate an American judge was now experiencing something completely foreign, being outprepared. "I think you'll find that the notification period is ambiguous," Novak countered, but his voice had lost its edge. "It's only ambiguous if you haven't read the contract carefully," Judge Caprio said. "Let me read it directly." The judge opened the contract and quoted from memory. "Upon notice of an event satisfying the criteria established in this clause, the notifying party shall immediately communicate such notice to the other party without unreasonable delay, understanding that delay of more than 15 business days shall constitute waiver of force majeure protection." Judge Caprio looked directly at Novak. 24 days is not 15 business days. It's significantly longer. So either your client invoked force majeure improperly, which means they waived that protection, or they knew about the situation before the official invocation and chose not to notify your distributor partner until they had a legal advantage. Which is it? The room was completely silent now. Even the camera crews had stopped moving. This was no longer a confrontation between a European broadcaster and an American judge. This was a masterclass in preparation, destroying arrogance. Novak tried a different approach. "You're taking an extremely narrow interpretation of international commerce standards. European courts would understand these clauses differently than American municipal courts." Judge Caprio's response was immediate and devastating. "Are you suggesting that contract law should be interpreted differently depending on the geography of the courtroom? That a contract written in English to be performed by parties doing business in Rhode Island under Rhode Island law should somehow be subject to a European interpretation that contradicts the actual language of the document?" The judge stood up, walking around his bench to face Novak directly. "This is the United States, Mr. Novak. In this country, we have a legal principle called the plain language doctrine. It means that contracts are interpreted according to their actual words, not according to what someone wishes they said or what might be more convenient in another legal system." Novak's carefully constructed facade was crumbling. He tried to make a point about the complexity of multinational dispute resolution, but Judge Caprio cut him off with surgical precision. "Mr. Novak, I have a question for you. When you were preparing for this hearing, did you research Rhode Island General Law, Title 6, Chapter 34, regarding commercial contracts and dispute resolution?" Novak hesitated. His team had researched primarily international trade law. They hadn't spent much time on Rhode Island state law because they assumed it would be irrelevant. The judge's eyes narrowed slightly. "That hesitation tells me everything I need to know. Section 34B of that statute explicitly permits courts to ignore clauses that appear designed to circumvent legal standards in the jurisdiction where performance is taking place. In other words, even if your European interpretation was valid, which it isn't, it would still be inapplicable in this Rhode Island courtroom." Judge Caprio returned to his bench. "Now, let's talk about the real issue. Your client is claiming 12 million euros in damages based on allegedly incomplete shipments. But according to the documentation your team provided to this court, your client actually received 87% of all contracted goods. They rejected the remaining goods as substandard without allowing the American distributor the opportunity to remedy the situation, as required by the contract's Article 9. Novak tried to jump in, but the judge held up his hand. I'm not finished. Your team has also claimed that the distributor's failure to meet the January delivery deadline constitutes material breach. However, the ship carrying those goods sank in the Atlantic Ocean on December 28th. That's not breach of contract. That's an act of God, which falls outside the definition of contractual default in every jurisdiction, including Europe. The camera crews captured the exact moment when Novak realized he had been completely outmaneuvered. His entire case, which he had brought to Providence believing that an American small-town judge would be overwhelmed by its complexity, had been systematically deconstructed by someone who had actually done the preparation work. Here's what's going to happen, Judge Caprio announced, his voice carrying absolute authority. I'm ruling in favor of the American distributor on all counts. Not only will your client pay the court costs associated with this hearing, but they will also be responsible for compensating the distributor for the value of the goods they rejected without proper cause. Novak stood up, his media composure completely gone. This is outrageous. You're allowing American corporate interests to override clear contractual obligations. Judge Caprio's response was ice cold. Sit down, Mr. Novak. You will address this court with respect. I've been practicing law for 52 years. I've tried cases in 6 different countries. I've studied comparative law, international commerce standards, and the legal systems of more than 30 nations. So when I tell you that your argument was not only weak, but fundamentally flawed, I'm speaking from experience that exceeds your entire legal career. The judge removed his glasses again, a gesture that by now carried enormous weight. What happened in this courtroom today is a perfect example of why preparation matters more than personality. You came here believing that your reputation, your media presence, your European credentials would be sufficient to overcome the actual facts of this case. You were wrong. You came here unprepared because you assumed this was a simple matter where your confidence would carry the day. You were wrong again. Judge Caprio looked directly at the camera crews. And for everyone watching this, I want to make something clear. Justice isn't about who has the better suit or who can speak more languages or who is more famous. Justice is about truth, preparation, and the courage to hold powerful people accountable even when they arrive in your courtroom expecting to be treated as something special. The ruling stands. This case is dismissed in favor of the defendant. Mr. Novak, you have 30 days to file any appeals in the appropriate appellate court. As Novak was escorted from the courtroom by court officers, his carefully maintained European sophistication had completely disintegrated. The cameras captured the walk of shame. They captured his producers trying to manage the PR disaster unfolding in real time. They captured the legal students in the gallery, standing and applauding Judge Caprio. But the story didn't end in the courtroom. What happened in the days and weeks following this confrontation revealed something far more significant than just a judge winning an argument. The video went viral across the entire European continent. It was watched by lawyers in Brussels, judges in Berlin, legal academics in London. It was shared with commentary about American judicial excellence. It sparked conversations about arrogance and preparation. It became a teaching tool in law schools across Europe. By the next morning, the video had been viewed over 5 million times. By the end of the first week, it had surpassed 50 million views. Legal commentators across Europe began analyzing what they were calling the most significant public demonstration of judicial preparation they had ever witnessed. Novak's reputation never recovered. The broadcaster who had built his career on making powerful people look foolish had been completely dismantled by someone he had dramatically underestimated. His European news organization initially tried to spin the narrative, claiming that Judge Caprio had somehow been unfair, but that argument collapsed when independent legal experts reviewed the case and confirmed that the judge had been absolutely correct on every single point. Within 2 weeks, Novak had resigned from his position at the European network. He released a statement saying he was taking time for personal reflection, but everyone understood what had really happened. He had been exposed as arrogant and unprepared, and the exposure had been broadcast to a global audience. Judge Caprio, meanwhile, became something of a legend in international legal circles. Universities invited him to speak about preparation and judicial authority. Law firms studied his methodology. Other judges reached out asking for advice about how to handle high-profile cases involving international parties. But Judge Caprio never spoke about the case with arrogance or satisfaction. When reporters asked him about the confrontation, he said something that captured his entire philosophy. "I didn't do anything special that day except prepare thoroughly and hold a powerful person accountable for their unprofessionalism. That should be the standard in every courtroom in every country. When someone comes into your space with arrogance, when they assume that preparation doesn't matter, when they believe their reputation supersedes the requirements of excellence, you have a responsibility to show them that none of those things matter except the actual work you do." The American distributor who had been fighting against the European corporation for months finally received justice. They were compensated not just for their immediate losses, but for the years of legal fees they had accumulated fighting against a powerful corporation with resources they couldn't match. The judgment became a landmark case in international commercial law, cited in legal proceedings across multiple countries. More importantly, the case established something intangible but enormously powerful. It demonstrated that integrity and preparation matter more than fame, resources, or international reputation. It showed that a small-town American judge could stand toe-to-toe with a powerful European media personality and win not through politics or luck, but through superior knowledge, better preparation, and unwavering commitment to justice. Judge Caprio never discussed the case with pride, but he did reflect on what it meant for the broader legal system. When asked what lesson other judges should take from this confrontation, he said something that would be quoted in judicial seminars for decades. Real authority comes from knowing your work better than anyone else in the room. When you've prepared thoroughly, when you understand the law deeply, when you've researched every angle, then you can sit in judgment without fear of challenges from any source. Arrogance without preparation is just noise. Preparation without arrogance is justice. That philosophy, lived out every single day in Providence Municipal Court, was what made Judge Frank Caprio one of the most respected judges in American history. In that single confrontation with Victor Novak, that moment when an arrogant European broadcaster learned the cost of underestimating someone's commitment to excellence, became the perfect illustration of everything Judge Caprio represented. The video remains one of the most watched legal proceedings in internet history. It's been translated into more than 40 languages. It's been studied in law schools across the world. Legal experts continue to analyze Judge Caprio's performance as a masterclass in judicial authority, legal knowledge, and the power of preparation. But for those who knew Judge Caprio personally, this case was just another Tuesday in Providence Municipal Court. Just another opportunity to demonstrate that real leadership, real justice, and real authority come from doing the work, preparing thoroughly, and never allowing anyone, no matter how famous or powerful, to convince you that the fundamental standards of excellence somehow don't apply to them. That is the legacy of Judge Frank Caprio. Not just in this single confrontation, but in thousands of cases handled with the same commitment to truth, the same dedication to preparation, and the same unwavering belief that justice must be delivered fairly to everyone who walks through those courtroom doors, whether they arrive in designer suits or worn-out shoes, whether they come as famous broadcasters or struggling citizens.